Okay. Cal is ready.
Good morning.
All right, let's do it.
Good morning, Your Honors. May it please the court, Kenneth Chase for the appellant, Deanna Welsh. May I reserve 5 minutes for rebuttal?
Yes, sir.
Your Honor, this case presents the power of the court to enforce its own orders. The court does not have the power to enforce its own orders. What power does the court have? There's no more foundational principle in law than the court's enforcement of its own orders. The cases that this court has held, for example, in the Alexander v. Harris case and in the Castleberry case, the court has specifically said that when there is an interplay of competing interests with a Florida statute that's essentially a creditor shield statute versus another compelling interest, the other compelling interest in those cases, it was enforcement of support orders, overrides a statutory creditor shield. Here, there's an even more compelling interest at play, which is the court's own power. There's no credible dispute that the Connecticut order was properly domesticated in Florida. There's no credible.
Let me just stop you right there and let me ask you a question before you go any further. The order that we're dealing with is strictly the contempt order.
That's right, Your Honor.
Okay, we're not dealing with the 2012 final money judgment.
That's right, Your Honor.
Okay. Castleberry. Okay. That had to deal with the Spendthrift Trust and the garnishment of the distribution monies from the trust, not the garnishment of the trust itself,
Your Honor's absolutely right.
which is completely different than garnishing an exempt retirement account.
Your Honor, we believe it's part of the same coin. And
Well,
Burlington
and
versus
so let me add, and there are all sorts of allegations of fraud. I've looked through the Connecticut, I think it's Connecticut, right? The cases, and was there any allegations that the IRA, that there was monies fraudulently transferred into the IRA?
No, not in this record, Your Honor. At this time, the Hughes case does hold, in the bankruptcy case, that if there's money coming in and out, then it's not exempt. We haven't established that on this record.
And I think that's what distinguishes your case from the, I think it's Gepfrich, I don't know how to pronounce that, versus Gepfrich, which was a fraudulent transfer in that case. But you don't have that here.
Not on this record, Your Honor. We believe we actually do have it.
Well, but I only can go, and you agree, I can only go by the record that's before us.
Of course, Your Honor.
Okay.
And the order that is before Your Honor is an order that held that this order is not enforceable in Florida because, number one, it's non-final, which it's not the case at all. In a domestication of a foreign order from a sister state, clearly the standard is whether it's a final order in that other state. For that execution issue language, not relevant in Connecticut, and even if it was,
Well, it's a contempt order.
contempt order.
It's not like a final money judgment like the other one was. This is a contempt for failing to pay the fines, right?
Absolutely, Your Honor. And no case in this record has held that a contempt order is limited by the IRA exemption for a retirement account. The scope of the court's contempt power is essentially plenary, bounded only by due process, and the case law says by the court's imagination.
Okay, so what case says that a contempt order can attach to exempt property like the retirement account?
Well, Your Honor, the case law actually states that when we're dealing with contempt, exemption is inapplicable, and that's the law of this case.
What are you talking, the other state law or our law? Because
Actually, it cites
Florida on
It
our-
cites VIX. It cites Wix in stating that, which is our law, in stating that they're like ships passing in the night. The contempt proceedings, this contempt order, is not a judgment collection by a creditor. It's not. It's out of that realm, and that's what the court held in Connecticut. In this case, stated this is not. The defendant presented that. It said, "Hey, you can't consider this." And in that context, albeit a different context, the court said, actually, we can. And in fact, we're not in the realm of judgment collections by a private individual. We are in the realm of enforcement of a contempt order. And there are so many aggravating circumstances in this record, Your Honor, that this is the case for the court to define that principle where
I can't find a case. Let's just assume that it is, we give it full faith and credit, it is a final order. You do have some law on that because it doesn't appear there's any further action required, so let's go beyond that. I can't find a case that allows a court to require a party to divest themselves of a federally protected financial instrument under 222.21 because it requires IRS action or proof that he didn't maintain it per the IRS regulations, or there's no proceeding determining that it's no longer exempt. My problem with this case is your brief doesn't have a whole lot of argument about this exemption other than to talk about Berlinger, which I authored, but Berlinger does not divest a party of the trust. It's just a discretionary trust, and that particular husband was just, taking out money, and they knew it, and he wasn't paying his wife. Now, I agree with you that if this doctor takes out a distribution, sure, but help me out. I mean, what case gives the court the right to order a party to divest themselves of a federally protected financial instrument?
So, Your Honor, there's no case that says that the court can't pursuant to enforcement of a contempt order. There's no case in the record that says.
How are we gonna write that we can?
Okay, so
Equity?
in this way, Your Honor, the court has gone up to the line and said, we'll impose a garnishment for distributions out of this particular entity that was statutorily protected. That's Burlington, that's Alexander. Okay, that we're already there. Here, the court in Connecticut has held, we are outside the realm of judgment collections by a private individual. We are specifically in the realm of enforcement of a contempt order. Okay, so the court.
I'm sorry to interrupt you, but in the Connecticut cases, there was fraud, and like you've conceded here, we don't have that in our record.
Well, fraud that would cause the asset to be not exempt.
Right.
Here, it's irrelevant whether it's exempt. That's the position we're taking, is that in the enforcement of a contempt order, it doesn't matter if it's exempt, and no case has held.
But there are cases. There are cases actually that deal with this issue where there's fraud. That's where people take their money and go hide it into Homestead, and there's the law of fraudulent transfers deals with that. And so there is cases on this point, but what we don't have is any guidance as far as a contempt to disregard the exemption.
Well, Your Honor, we actually do have quite a bit of fraud in this case, which is what led to the contempt finding in 2017, the violation of a court order, the fraudulent transfer of over $2 million.
But we don't have any, as you conceded, tied to the IRA, to his IRA account.
Correct, Your Honor.
And I think that's a critical point.
It could be, Your Honor. What we do have is case law in Florida indicating that even a homestead can be pierced by a contempt order, even the protection of a homestead. And there's no differentiation that I view between.
And in those cases, isn't there some sort of allegations that monies were divested or purchased, monies were transferred with the intent to defraud creditors for the purchase of those homesteads?
There's two routes to that destination, Your Honor. One is there's fraud, as Your Honor articulated. We're saying there's another road to that destination, which is enforcement of a contempt order. The court's power can get there without even a finding of
And
fraud.
that's the case I'd like you to share with me.
So, that's the case that's a blue ocean. No case says you can't, and the scope and
But
the
that's not a
breadth.
really good argument.
Your Honor, I believe it is, because there is this case law as to the power of the court, is that the power of this court is so foundational to the entire system, there can be virtually no stronger power. And if the court can't pierce a statutory creditor protection device under state law, there's no differentiation as to federal law. And moreover, in this case, in the body of the case law, an IRA is not impervious to being attached or to have orders executing on it if as Your Honor said, there's fraud. Here, it's even stronger than fraud. There is fraud underlying it, and not just that. Back in 2019, Your Honor, February 2019 order, the court listed a number of aggravating circumstances. That was 2019. After that, we have the February 19th, 2020 order. We have the August 14th, 2020 order. Each time the defendant is ordered to do something, he violates the order again. And not just his order, not just the order requiring payments. The defendant didn't even produce his quarterly asset disclosures.
Let me ask you this with respect to the contempt order. Are you seeking full faith and credit for the capias?
Yes, Your Honor. The entire order.
And the case on point that would allow full faith and credit for the capias to issue here in Florida?
Well, the capias, there'd be a couple of mechanical maneuvers, Your Honor,
Right.
that would need to be domesticated. So that would flow from the proper domestication of that order, and the capias part and parcel and attached to the order.
Okay, and your position was that domesticated along with the order?
And it was, Your Honor. It was domesticated along with the order, full faith and credit, bedrock principle. This order that was issued in
But
Connecticut.
there's probably has to be some additional steps for a capias to issue here in Florida, because as opposed to a Connecticut capias, you agree?
I agree operationally, Your Honor, but none of those are insurmountable if the court reverses as we're requesting. But yes, there are some mechanical steps that need to occur for local law enforcement to then enforce what would be the domesticated version of the capias, be a writ of bodily attachment or some other order that this court could direct the lower court to issue based on the capias that was already issued. How many chances should the defendant have to comply with court orders? The defendant was ordered to not dispose of his assets in 2012, violated that willfully. In 2015, the judgment is affirmed. In 2019, the contempt judgment is affirmed. He's had every opportunity to go back and ask for that order to be reversed and to ask for it to be modified. The argument, Your Honors, that the defendant makes is, well, because I could go back into court and ask the judge if I have some financial difficulties, if I can't make the $25,000 payment, because I could do that, then therefore the order must not be final.
You're talking about the December 23rd, 2020 order,
Right, which is
and that's
completely
a
fine.
contempt order, right?
Yes,
It had a purge provision of $75,000 to post a bond. And you're trying to enforce that and say, we domesticated, therefore we can get to 75,000.
among other things, Your Honor,
But
yes.
the order doesn't actually say all that. I mean, it's not a judgment, it's a contempt order. I'm just having trouble following, how do you domesticate a contempt order? You didn't ask to have this guy picked up and enforced it in Florida, put him in jail. Is that true or false?
Not yet, Your Honor.
Well, okay, I'm just trying to find out where we
There
are.
are a couple
today.
mechanical steps, Your Honor, yes.
Okay, so you think we should go outside the box and do something that no one's ever done and say, yes, you can domesticate and enforce a contempt order and get a money judgment?
I don't think it's outside the box, Your Honor. The
Well,
box,
what's the case that says it's inside the box?
the case that says inside the box is the scope of the court's contempt power.
But that's not a case. That's just a general concept.
Understood, Your Honor.
Okay, fair enough.
But there's to hem the court in terms of its ability to enforce its own orders. If the
Wait,
order
wait,
was,
this is a Connecticut order, and the Florida order declined, correct? Found two
yes,
objections. Is the standard review on that order abuse of discretion, or is it de novo?
they know, Your Honor.
So the court had no discretion to say, I'm not gonna be the first guy to go outside the box and let you domesticate this judgment and then claim it's a final judgment.
Well, the court went further than that. The court, Your Honor, in the lower court said that this is not a order that can be recorded and domesticated because it's a non-final order, which is not true. It's not a non-final order under Connecticut law or Florida law. That's completely incorrect ruling of law. And if the court reverses as to that point, which I believe the court should, then therefore it is a Florida order entitled to full faith and credit as if it were issued by a circuit court in this state. The Connecticut Florida distinction goes away.
I got you, I understand the argument.
The fine, the $75,000, that's tied to I believe what the court said in Connecticut, that's the $25,000 a month that the plaintiff has been out for the, for Dr. Martinez's actions in failing to pay or provide the financial statements, right? I think that's in the
Your Honor,
contempt. Having done civil contempt orders myself, I think that $75,000, although it says it's like a bond, it is money that's supposed to go to Ms. Welch. Is that right?
Correct, Your Honor.
Okay.
You've got
Yes.
5 minutes, so as you answer, I'll let you finish it, but it's gonna chop into your time.
I'm gonna make one point then, if I could reserve it, Your Honor.
Yes,
The defendant, the 75,000 is only the violation of the August 14th, 2020 order. He's violated the 2017 order, the 2019
Those aren't
order.
before us.
They're not before us,
Right.
but this is, that's
I
only a
understand this is
portion
the first. I
of his
understand.
non-compliance with
Yeah.
court orders. If I could reserve, Your Honor.
I'm gonna save you 5 minutes, okay? All right. Is it Mr. Zinn?
Yes, good morning, Your Honor.
You've got 20 minutes. What do you got to say about all this?
Thank you, Your Honor. Brian Zinn, representing the appellee. Well, as Your Honor pointed out at the very beginning, this is an exempt IRA under 222.21.
But let's talk about the bigger issue.
Okay,
What about all this domestication and enforcement? Whether this is exempt or not, if it was properly domesticated, then you'd claim an exemption. So you're trying to bypass, say that moots out the proper domestication and enforcement because it's exempt. But is this an enforceable judgment on its face?
well, Your Honor, we argue that it's not for several reasons.
Why don't you start there, if you don't
Okay.
mind?
Okay, well, one of them is that if you look at the language of the order,
It doesn't say for let execution issue.
that's one of the things, but it also, all it says is that the defendant remains in contempt and a court will issue a capias. It doesn't say,
And the court did issue a capias.
yes, capias, sorry. It doesn't say that the defendant has to pay any money to the plaintiff. It just says the defendant will be arrested, and if he's arrested, there are 2 conditions for release. One is posting of a bond with the court, and the other is providing a financial
And
statement.
that would be posting a bond in Florida? They could have him
This
hauled
is-
back to Connecticut?
I don't know the answer to that, Your Honor,
Okay.
but that's what the Connecticut order says. There's no Florida order saying he has to post a bond. There's only a Connecticut order that says it. But what it doesn't say is that the defendant has to pay any money to the plaintiff. And,
Well, the $75,000 is a purge.
well, it's actually just a condition of his release. It's not a purge of the contempt fine itself. The contempt fine is over $2 million. It's from November.
Well, to get out of jail card.
Yes.
Okay, so
Well,
move
up
on.
to that point, he only owed $75,000. She couldn't, the judge could not have imposed anything more than that, right? I mean, he's 3 months in arrears. So $75,000.
Right, Your Honor, but they're arguing, they didn't argue it on this appeal, but they've argued
But
below.
what further action was needed? It says if you get arrested, you post a $75,000 fine and you file, period. You don't need to go back in front of this judge at all if he's arrested.
Well, there are many cases that hold, including the Bowen case and the Parisi case, that you are not allowed to incarcerate somebody unless you can show, on a contempt fine, unless you can show that there's a present ability to pay. And you have to make a finding of that. And that's why
But the-
every time he's been in front of the Connecticut court, they've had to make that particular finding. So if you look at the order, it actually, in the
Are you-
train,
I'm sorry, so you're saying that that should have, well, wasn't that determined by the issuance of the contempt?
Yes, at the time, that was in December of 2020, that was almost 2 years ago. And so the defendant, if he does go to Connecticut and get arrested in Connecticut, or if somehow he can get arrested here in Florida, before anything can be imposed on the defendant, there has to be a finding that he still has the ability to pay the $2 million contempt fine. And that, and therefore, our argument
But
is.
isn't that something that he needs to be bringing up before the court in Connecticut?
If he, whichever court he appears
Because
before.
otherwise, this would just keep going and you would never be able to hold him in contempt. If this is subject to continual ability to pay. I mean, because here we have a contempt order, it says, you know, there's a purge, what he's supposed to do, it's very definitive. Contempt orders are, you know, a thing of their own, and exist. And, you know, I see this as a final order because it accomplished everything that it was supposed to accomplish. And I think the cases are consistent with that. So, you know, if this is final, then, I mean, I think that brings you to the second issue as far as the exemption, which we
Yes,
discussed
but
at length at the,
It also brings us to the issue that, let's say it's a final order for some reason. There's nothing showing that he has to pay any money to appellant in this order.
other than the history, if you go back and the trial judges go back and look at the history.
Right. But they
I mean,
can't-
that's what the $75,000 was for.
Right, but as Judge Creer said in the transcript below, you docketed the wrong order. You set this up the wrong way. And Judge Creer actually asked.
Well, they actually domesticated the other order. So I'm very confused by that transcript, I have to admit.
They domesticated the judgment.
They did both. If you
Yes,
look at
but in a
it,
different case, not in this case. They filed.
you're saying the final money judgment was domesticated in another case, but that's not even, as conceded by opposing counsel, that's not even before us now. We're
That's-
only here on the contempt.
That's correct. So we filed our claim of exemption because an IRA is basically exempt under the Internal Revenue Code at 222.21. The appellant does not dispute anywhere that the IRA was maintained in accordance with Section 408 of the Internal Revenue Code. There is no argument that he made anywhere as to why 222.21 doesn't apply to the IRA. And this is not the first time that they tried to garnish the IRA. They did it up in Connecticut as well. There's a transcript from December of 2019 in the record. It's at the appellant's appendix at page 188, where they garnished the IRA. They were ordered to release it by the court. They actually say, this is plaintiff's counsel in Connecticut saying, informing the court, the defendant moved to dissolve the attachment, and it's an exempt asset, it's an exempt IRA. They moved to dissolve the attachment. We didn't dispute it. And Your Honor ended up ordering us to release it. I think the order was entered April 9, 2019. They garnished the same Schwab IRA before. They acknowledged that it's exempt, and then a year and a half later, they garnished it again down here. So we filed our claim of exemption, and then they filed a 99-page objection to the exemption. And in one sentence, only one sentence of that entire 99 pages, do they say why the IRA is not exempt. And they say that the Connecticut Superior Court further held that notwithstanding the usually exempt status of retirement accounts, the exemption does not shield judgment debtors' retirement accounts from enforcement under the court's contempt powers. And that's not what the Connecticut court said. The Connecticut court said that the issue presented, and this is on page 130 of the appellate's appendix. This is a ruling from Connecticut. The first sentence, the issue presented is whether the court can consider a person's otherwise exempt retirement accounts in determining his ability to pay a fine imposed as a sanction for civil contempt. And they answered in the affirmative that you can consider it.
That's kind of the Bowen analysis you were alluding to earlier.
Yes, and they even cite Wicks on it, just like appellant's counsel says. a court can consider otherwise exempt assets. It doesn't mean you can garnish the exempt asset, it's exempt. And the Connecticut court actually cites the Connecticut statutes exempting. Say these statutes most certainly make the retirement accounts in this case exempt. That's page 134 of the appellant's appendix. There's no other reason given in the objection of the 99 pages as to why this is exempt. And Judge Creer points that out as well. The last resort argument was not argued below. It was thrown into the appellant's brief on appeal. We respectfully request that the court should not consider that argument. But the last resort that the appellant can somehow garnish a retirement account as a last resort, the cases that are cited, most of them deal with the spendthrift trust, all of them deal with alimony and child support, and all of them deal with only disbursements from the corpus, not from the corpus itself. The Bacardi case is a spendthrift trust, alimony, only disbursements. The Berlinger case, same thing. The Castleberry and Alexander cases, same thing, child support. And the Alexander case, which I believe Your Honor authored as well, is there was pointed out that there's actually a statute for spendthrift trust showing that there's an exception for child support, basically. That's 736.0503. The Gepfich case, that's the homestead issue, that's alimony again. It was actually entered 10 years before Havico came out.
Well, I think he's conceded there's no case on point.
Okay,
So telling me there's not on point, I think, it's repetitive.
okay. So here we don't have alimony, child support, spendthrift trust, a home. We don't have any disbursements. So all we have are two statutes, 222.21 and Internal Revenue Code 408. And there's nothing from the appellant saying why those wouldn't apply. We also pointed out in the trial court below and also in our brief that they failed to comply with the Florida statute on garnishment. They were supposed to serve the defendant with the notice of the garnishment within 5 business days of the writ being issued or 3 business days of the garnishee being served. The latest would be May 13th for that. There's a typo in my brief on that. I had put May 11th, I believe, but May 13th would have been the deadline. They served it instead on May 26th, nearly 2 weeks later. That's in our appendix at page 006. As the Little Brownie case stated and other cases, the garnishment statutes are in derogation of common law. They have to be strictly construed, and there is no exception for substantial compliance. There's no exception for lack of prejudice. If you don't comply with the statute, the garnishment is invalid. And the appellant has not mentioned this statute at all, either below or in the brief here, as to why the appellant has not complied. So we have an order that we contend is modifiable because there has to be a finding of ability to pay, a present ability to pay. We have a plaintiff, we have an order where it doesn't give the plaintiff the right to any money. And we have an order that doesn't say anything as to whether the plaintiff can execute. But even if it had, even overlooking all that, we had, and assuming we have a valid order, the IRA is exempt under 222.
But that wouldn't nullify the fact, let's say it is entitled to full faith and credit. The exemption issue isn't going to nullify. I mean, we can find that the order is entitled to full faith and credit and is a final order, right? I mean, the fact that they're not entitled to garnish the IRA doesn't nullify the fact that it may be a final order.
Yes, Your Honor.
Okay.
I'm saying.
Let me pose a question to you. If this domestication was within a reasonable time when the contempt order is issued, when the finding of present ability to pay was made, would you then change your argument that this would be that it wouldn't be stale on the issue of present ability to pay?
Exactly. Your Honor. I agree
Okay,
with
so,
that.
so your argument, if I'm trying to put it together, is that the finding of present ability is old because it was made in 2020.
Correct.
Okay, couldn't a trial court here make the fine, once it's domesticated, then proceed to make the finding of present ability?
It is possible, Your Honor, but then there would be a concession at that point that the order is modifiable.
Because I think you're going outside of what the case is, what we're confined to look at. If we're confined to look at the order itself to give it full faith and credit, and that it is final and it was valid when it was made, then I think that's what we have to look at. This issue of presentability, that's something for another day that a trial court could decide.
Okay, but if you are giving it full faith and credit, what are you giving it credit to be or do?
What it is, what it actually says it is.
But it doesn't say that the defendant is to pay anything to the plaintiff. It just says the defendant is to be arrested. It doesn't say you can go
Well, it's
after
to pay the
assets.
fine. It's to pay the fine. You're jumping the gun to the issue of the collection part. I'm trying to focus on the order itself first. That's for another day, it sounds like. So,
Okay. Well, in their motion for the writ of garnishment, they mentioned that they have a judgment where the defendant owes $75,000 to the plaintiff, and they refer to this order. And I respectfully submit that the order does not say that. The order just says that he's to be arrested and a capias is to be issued, and there are 2 conditions for release. That's all it says. But even if it's valid, and let's say somehow there's a construction of it that there's a money judgment due.
It's still an exempt fund.
Right.
You've made that point. Is there any new point you want to make? You only got about 3 minutes left.
And just that he also did not comply with the garnishment statutes, which are strictly construed.
All right,
Thank you, Your Honor. Thank
Thank
you for
you.
hearing me.
you're welcome. Mr. Chase, you've got 3 minutes left.
Thank you, Robert. In terms of the alleged staleness of the domestication occurred on February 10th, 2021. The contempt order was issued on 12/23/2020, so it was within a couple of months. The court specifically made a finding in the 12/23/2020 order that the defendant has the ability to pay. Specifically made the finding. So the notion that because he is in Florida, and says now that he doesn't have the ability to pay, that renders the order invalid.
and that finding of present ability to pay was because he had monies in the IRA, which is something the court may look at.
Absolutely wrong. Per the law of the case, among other things, the defendant had an opportunity to testify in that situation. The court specifically held on 2/27/2019. The statutes most certainly make the retirement accounts in this case exempt from a quote court order for the purposes of debt collection, end quote, and from the quote claims of all creditors. However, the present issue does not involve an attempt by a private party to collect a debt or the claim of a private creditor. Rather, it involves the question of whether a court can enforce its own contempt order. And in that context, and consider these assets in determining a contemnor's ability to pay. The exemption statutes simply do not address this issue.
Do you agree with his argument that contempt proceedings are strictly construed?
Generally, Your Honor, yes.
Okay.
Yes, and Your Honor, there couldn't have been more strict compliance here. He was in arrears more than just 3 months when this 8/14 order was issued.
But I guess my question is leading towards, if the order has this $75,000 as a capias or a bond you're supposed to post, and now they want to turn that into a collection proceeding, isn't there some ambiguity there?
It could be labeled a collection proceeding, but this is not fundamentally a collection proceeding. It's enforcement of a court order. And in fact, what the court did on 2/19/2020 in paragraph 8, and this is page 142 of the record, the court in paragraph 6 on the prior page ordered the defendant to make payments of $25,000 per month. The 2 million plus contempt fine was commuted down to 25,000 per month. And in paragraph 8, the court specifically says, given these facts, it will be up to the plaintiff to decide what remedy to employ to collect the compensatory fine if the defendant does not comply with paragraph 6 of this order. Where I read that, Your Honor, is that the court delegated the authority to channel the court's power to enforce its own order to the plaintiff.
You're down to about 20 seconds.
I'll end with that, Your Honor.
Okay. Fair
Thank
enough.
you.
All right, gentlemen, I want to thank you both for your argument. Hope you have a great day.
Thank you.
All rise.
Good job.
Thank you. Travel safely.
Thank you.
you too.